Welcome back to Squawk Box. The CFTC has filed lawsuits now against several states, including Illinois, Arizona, and Connecticut, over their proposed ban on prediction markets, sports, and election betting. Joining us right now is CFTC Chairman Mike Selig. Good morning to you. This is one of those. This is a federal issue versus a states' rights issue. That's what this seems to be about. Make the argument to the American public about why you're on the right side of this.
Well, over the past year, we've seen a number of states file more than 50 lawsuits against CFTC-registered derivatives exchanges. And Congress was very clear when it drafted the Commodity Exchange Act that the CFTC is the federal regulator and that there is a comprehensive federal regulatory scheme around the offering of derivatives contracts. And we've got a broad definition of the term commodity. The CFTC regulates commodity derivatives, and that includes events on sports, on politics, and virtually everything else except for onions and motion picture box office receipts. So when we saw these state regulators suing our exchanges, we had to step in.
But Mike, you do recognize, at least on sports, let's just talk about sports for a second. You know, for a very long time in this country, there were remarkable debates taking place in various states, including in New Jersey. We had Chris Christie on recently about this, about whether there should be sports betting, whether it should be allowed across the country or in these states. Some states made a decision to do it. Some states made a decision not to do it. And there is an argument that what this sort of broad definition of commodity looks very much like classic sports betting.
The way that our federal regulatory scheme is set up, when you offer a derivatives contract, whether it's on sports, politics, or anything else, that's within our regulatory scheme. And of course, there are these state laws, and when casinos and sports books are offering betting and wagering for entertainment purposes, that's regulated very differently. But the issue comes when you have a conflict between these state laws and our federal regulatory scheme. And what we're seeing is an attempt by the state gaming commissions to effectively nullify federal law. They can go to Congress and have a change made in the statute, but that's not what they're doing.
But they would argue that you're trying to nullify effectively their powers, and that you are pretending in one instance that what you're calling derivatives trading is actually sports betting, right? I mean, that's the heart of what this case is about.
That is the heart of what the case is about, and it's a question that's a technical one as to the applicability of federal law to these activities. And when an exchange comes in and registers with the CFTC and obtains a license to offer derivatives, they are permitted to offer derivatives on sports and on politics. And the fact that there's state laws that permit casinos and sports books to offer it in some states and not in other states, that's a state law issue. The question as to whether these products are permitted under the state laws, that's a separate issue, but the federal laws permit it. And so when you're talking about a federally regulated derivatives exchange, it's able to offer those products across the country under a federal regulatory framework. And we're happy to engage with the states on what the policy should look like. We actually have an advance notice of proposed rulemaking out there. So the states should engage with us and work with us, as should every other stakeholder. But this question of the applicability of the law, it's black letter. It's in our statute. And so as chairman of the agency, I have to enforce that.
Mike, you're the chairman of the agency now, but because this has been so controversial, I wonder when a new regime comes in, they may have different views on some of these things, and could all of the things that have been legalized through the CFTC at this point get turned down or turned the other way under a different administration?
Well, the prior administration did attempt to ban these products, and the court said that that was arbitrary and capricious because, again, our statute is very broad. It allows for these products to trade. Of course, the nuances of what the rules should look like around these products, that's something that we're going to engage with stakeholders on, and we'd expect any future administration to do the same. So, of course, the rules are always subject to change. We've got a great administrative procedure process in place so that those rules are always proposed for the public comment and given notice to the people, but we've got to make sure that we're enforcing our statute as an agency.
Mike, let me ask you a different question. There's just a recent decision by Polymarket to eliminate a specific trade around some of the issues that are taking place in Iran right now. And there's a question about if you're a state, whether you should have any say over that at all. What do you think?
Well, the states should not have a say over our federally regulated derivatives markets. To the extent that there are products that are offered illegally off exchange in an offshore market or that sort of thing, I don't know this specific contract that you're mentioning, so I can't comment on the specifics, but there are nuances as to whether something's traded on a federally regulated exchange or if something's offered over the counter. And to the extent it is a swap or a type of derivative that's offered over the counter, we still regulate that, but there are some nuances in our statute where states may have some authority in the case of things that are offered outside of the federally regulated framework. But again, we believe that the CFTC is the federal regulator of these markets. The statute intends to have a single rule book for derivatives transactions, and that means that state laws do not apply to our exchanges. And that's for good reason, because we saw at the turn of the century a patchwork of these state regulatory regimes. Some states wanted to ban futures contracts on grain. Other states permitted it. Other states had different rules and regulations than the prior state. And so it was a complete mess, and the Congress established a federal regulatory framework
you do
for
recognize
these
conceptually on the sports front that states do have laws about this, and that your sort of recreation of this in a different context by arguing that they are now derivatives is just a fundamental sea change in how people have thought about this up until now.
I understand that, and these products are structured as derivatives. They're not structured with a house model, as you'll see in the casinos. So they are different products, but you have to recognize as well that the states have laws on the books prohibiting futures contracts as well, and those laws are not valid.
But in terms of how consumers see this, they see them, I think if we did polls, they would tell you that they're the same thing.
They're structured as different products. You could say the same about an insurance contract relative to a derivatives contract. If it's structured as a product within our regulatory framework, we regulate it. Just like if you structure something as a security, it's regulated by the SEC, not as insurance or as gambling or casinos.
Let me ask you just
we have different regulatory frameworks.
Philosophical question. If you win, it means that all of the states' rules and laws around sports betting effectively everything would move towards these derivatives or this structure that you're talking about and would effectively make moot the state's laws. Is that your understanding of what will ultimately happen?
I don't necessarily agree with that. I think that there's a real reason to have these casino regimes and sportsbook regimes. They're more for entertainment, and people walk in, walk out of a casino and place bets, and they do that for entertainment. Our markets are very heavily regulated, and so there's not going to be the I think, need or desire to offer the same level of protections and all of that across the board, but some will opt for that model, and of course it's got a very heavy regulatory overlay attached to it, as the state casino regimes are regulated just very differently. So I think there will be some regulatory arbitrage. Some will want to offer intrastate versus across state lines, but these are different products. They're regulated differently, and I think that's the important takeaway.
Mike, I want to thank you. Appreciate it.